Hello again, friends, and welcome to another Title Tip Tuesday. I'm going to kick this installment off from home because home is the answer to one of the most frequently asked questions from realtors, lenders, and consumers alike. So that frequently asked question is, why do I have to sign off on a deed or a mortgage when A, I'm not on title to the property, or B, I'm not on the loan that we're getting to finance the house or to refinance an existing mortgage? It's a great question, and one that needs a little bit of understanding about Florida constitutional law. So Article 10 of the Florida Constitution covers what we call Homestead. And one of the major components of that section is the protection of spousal rights to the homestead, or when we understand the homestead as the principal residence of a couple, a married couple. So what the provision says, in essence, is that one spouse, by him or herself, cannot devise or give away an interest in the marital homestead without the signed acquiescence of the other spouse. So from a policy perspective, this makes a ton of sense, right? You don't want one spouse to be able to sell the marital home out from under the other. Similarly, you wouldn't want one spouse to be able to take out a giant home equity loan or mortgage against the marital home without the acquiescence of the other spouse. So that's the basis for the rule, the Florida Constitution, Article 10. And we probably need to ask ourselves, where does this come about, right? In what scenarios or what factual instances might this come about? Well, the one I've hinted at already is a non-titled spouse having to sign off on a deed to the property. So this might occur if, for example, Jane and John Doe live in their marital home together currently, but Jane bought the house when she was single, before they got married, and then they moved in afterward. So nothing has changed as it relates to the official title of record, but now they live in the home and make it their marital homestead. The Constitution, the Florida Constitution, is then triggered to protect John's interest from Jane transferring it without his acquiescence. So in that case, if Jane and John were selling their marital home, even though John is not on title, he would have to sign off on the deed transferring their marital interest and his individual interest to the buyers of that property. And the other example is when a couple is either taking out a mortgage or refinancing an existing mortgage, and only one spouse is on the loan. I hate to do all the air quotes today, but those are that's the terminology we get from people asking the questions: is why do I have to sign off on the mortgage when I'm not on the loan? So in this scenario, one of the spouses might have better credit than the other. And so by using just his or her credit individually to originate the loan, the couple might get a better interest rate or terms on the loan. In the industry, we call that spouse that's not, quote unquote, on the loan, the non-borrowing spouse, because there's no personal promise to repay the sums that they're borrowing from that non-borrowing spouse, because their credit, their personal information was not used to originate the loan. But even though that non-borrowing spouse won't have to sign the promissory note or lots of the other loan documents, he or she will have to sign off on the mortgage to the property. Again, that's where the question arises. I'm not on the loan. Why do I have to sign this document? The reason is the Florida Constitution protects that non-borrowing spouse from the transfer of their interest in the real property without their acquiescence. So they have to sign to make that mortgage valid. Otherwise, the Florida Constitution would essentially invalidate the mortgage. So to unpack that a little bit so that you maybe understand a little bit better, a mortgage is a transfer of an interest in real property, right? You're pledging your interest. In this case, the non-borrowing spouse would have a marital interest or a homestead interest. You're pledging that interest to the lender, the mortgagee, in exchange for the sums that are being loaned with the home as collateral. So that's why the Florida Constitution kicks in here, because a mortgage is a transfer of an interest in real property. So those are the two scenarios we see most frequently, and it's where we get the most questions. If I'm a spouse that's not on title to the property, I'm probably going to ask the title company, why do I have to sign off on the deed transferring it to the new buyers? And if I'm a non-borrowing spouse on the loan, I'm more than likely going to ask the title company and the lender, why do I have to sign the mortgage? Well, that's why, the Florida Constitution. Hopefully that was of value. If so, we'd appreciate it if you shared the video, liked it, sent it to your friends or colleagues or clients who might find it of value as well. Please feel free to leave any comments below, or shoot us an email, or give us a call if you have any more questions. We look forward to seeing you at the next Title Tip Tuesday. Thanks for tuning in.